वेलकम टू कानूनी चर्चा। तो आज हम डिस्कस करेंगे ये जो नया भारतीय नागरिक सुरक्षा संहिता की दो सेक्शंस चैप्टर हम करेंगे। पहले चैप्टर आएगा ये चैप्टर 15 इस सेक्शन 210 और चैप्टर 16 की 223। Earlier, the corresponding section were section 190 of Code of Criminal Procedure 1973 and of 210 today of BNSS and section 200 of this Code of Criminal Procedure 1973. The corresponding in BNSS I have already mentioned 223. Now, what these two sections are? I will read out head of the first heading of these two sections. Section 210. Cognizance of offences by magistrate. This is heading of section 210. 210. तो इसमें क्या है कि मैजिस्ट्रेट किसी ऑफेंस का, then magistrate has to take cognizance of a in a criminal proceedings or otherwise has to initiate a criminal proceeding. What should be before him for taking cognizance of an offense? Otherwise, in very simple words. Now I will delve upon what you mean by taking up this cognizance. This is very important and many confusing, many conflicts, many judgments earlier. Now doubts have been cleared from time to time by the Hon'ble Supreme Court of India, by our various high courts of India. Now first I will go through what should be the matter for taking cognizance by a magistrate and in which matters what should be with the magistrate for taking cognizance in a particular matter. What are the requisites? First, cognizance of offences by magistrate. I will the offences, word is offences, not of offender, not of accused, but taking of cognizance is always of offences. So now I will go further. Subject to provisions of this chapter, any magistrate of first class. Magistrate of first class, now you will find, and any judicial magistrate of second class, specially empowered in this behalf. If second class judicial magistrate can take cognizance, can have proceedings as provided in section 210 and also 223 of BNS when he is specially empowered. Otherwise, judicial magistrate of first class takes cognizance, takes having intervention in these matters. Like before a judicial magistrate, a complaint of commission of offences is made. Now, what are the matter? How the magistrate in what matter he has to proceed, take cognizance, apply his judicial mind. All this I will read out. Any magistrate of first class and any judicial magistrate of second class, specially empowered in this behalf, under subsection 2, may take cognizance. This is a word may, discretion of the magistrate. He has to exercise, no doubt, discretion is always exercised by judicial officer or any other law is that in quasi-judicial proceedings, the discretion should be judicious, not arbitrary. Now, what are the matters? Upon receiving a complaint, if a complaint is filed, of the complaint is defined in this BNSS. Earlier it was defined in section 2 somewhere, this of Code of Criminal Procedure. Similar definition you will find having verbatim reference with regard to complaint, you will find in BNSS also. Including any complaint filed by a person authorized under any special law, which constitutes such offence. This complaint, as earlier of Indian Penal Code, now Bharatiya Nyaya Sanhita, and the complaint with regard to special offences also made inclusive. Now, second is on police report. You might be knowing that police report is submitted after completion of investigation. First FIR is lodged, thereafter investigation, and after that police report is submitted. Now, by digital mode, the complaint is also included in this the definition of complaint. Upon information received from any person other than police officer, or upon his own knowledge that a magistrate can suo motu take cognizance of an offence if the commission of offence comes to his knowledge, had come to his knowledge, and after that he can suo motu, or on getting information with regard to commission of offence, he can take cognizance. This is section 210. Earlier the section was 190 of Code of Criminal Procedure. This is the conditions, the matter in which the magistrate can take cognizance. Now I am very interesting here. You will find doubts, confusions in the minds of advocates. This law faculty members. Now amendment has been made in section 223. A proviso has been added which gives a right to accused to be heard while taking of cognizance. Now I will read it, very interesting, and I will clear today what you mean by while taking of cognizance, and how what are when this proviso come into operation. Now I will read out first 223, section 223. This is, its heading is examination of complaint. Complainant. Obviously, complaint is filed by a complainant. A magistrate having jurisdiction while taking cognizance. A magistrate having jurisdiction over a matter, or this territory jurisdiction, as well as jurisdiction with regard to taking cognizance of an offence, of a criminal complaint, you can say, shall examine on complaint, shall examine oath, upon oath the complainant and of the witness present, if any. I will give a pause. I will read out the word this while taking cognizance. Cognizance, but it means while taking cognizance. Now I will read out the proviso added. What is the proviso? Proviso that no cognizance of an offence under this section shall be taken by the magistrate without giving the accused an opportunity of being heard. This proviso was not earlier available in corresponding section 200 of Code of Criminal Procedure. It is added. It is the right given to the accused to be heard before taking of cognizance. Pre-cognizance mean, but magistrate has to take while taking of examination. He has to record statement of complainant and witness if any present. I will today confine today's discussion, today's episode only, but when the proviso became operative, the stage at which the accused is required to be heard. Now, then complaint is filed. Earlier, but the magistrate, after taking cognizance, while taking cognizance, asked the complainant to examine himself and a witness if he is accompanying him. Thereafter, the next course of action was 201, 202, and 203 and 204 of Code of Criminal followed. But I am not going further. I am today only touching while taking of cognizance, but it means and proviso. This proviso which has been added, how these both are related. तो इसमें क्या है, अभी इसमें बड़ा इंटरेस्टिंग है. तो इसमें ये हम आ जाएंगे, एक है कि what you mean by this word cognizance. This is not defined anywhere specifically in Code of Criminal Procedure earlier and not now in BNSS 2023. Otherwise, but its literal meaning and how different high courts, the Supreme Court of India has interpreted in different judgments this taking of cognizance. What do you mean by cognizance? Now, the word cognizance has its origin from the old French term conscience, which means recognition, wisdom, knowledge, familiarity, and from word cognize, which means to know, to understand, to drive. Latin word. These are French word and Latin words also. The word cognizance had not been defined. I have already mentioned that it is not mentioned in anywhere in Code of Criminal Procedure. What meaning of cognizance is derived from the number of precedents and judicial pronouncements. So now, dictionary meaning of to have knowledge regarding something, some facts, some intervention. Now, being a judicial magistrate, obviously a judicial intervention, application of judicial mind. While taking of cognizance, judicial mind is being applied, but that while taking of cognizance, thereafter examination of the complaint, but now with the addition of this proviso, now taking of cognizance begins only after giving opportunity. This is a pre-cognizance. I will read out again for the convenience. Provided that no cognizance means taking of cognizance has not yet taken. Before taking of cognizance means no cognizance of an offence under this section shall be taken by the magistrate without giving the accused an opportunity of being heard. I am now, what happens generally, I have already mentioned that when a complaint is filed, well, police report is given. Otherwise, this magistrate so moto get a knowledge and initiate this proceedings for commission of an offence. This is what is mentioned in 210 of BNSS. Now, I will speak now regarding BNSS, Bharatiya Nagrik Suraksha Sanhita. Now, but these I have repeated here again that this legal obligation has been made upon the magistrate to first issue notice before taking of cognizance. No court shall take cognizance means before taking of cognizance, a notice is to be issued. He should be heard prior to taking of cognizance. I mean, to taking of it means when a complaint is filed, the court obviously would entertain that complaint without making any formal order over that with regard to taking up a cognizance. He will entertain, and simultaneously, after entertaining, getting it registered in the relevant concerned register, whatsoever available with the office, its office, after seeking report of the concerned colors, he entertains and keep it as a record after getting, and order the issuance of a notice, because this notice is pre-cognizance. Opportunity is to be given pre-cognizance. In taking of cognizance, when he will take cognizance, then he has to examine the, no doubt, he has to see before. It is, this is obvious. This is that he has to go through the contents of the allegations of the complaint. Many cases where the word cognizance is defined, interpreted, talked about, the in Ajit Kumar Palit for the state of Bengal, 1963, Subramanian Swamy case, the word cognizance is missed significance in a criminal law procedure. Though cognizance not been defined, there is one more case, state of West Bengal versus Muhammad Khalid. This is 1995. R.R. Chadi versus state of UP, 1951 Supreme Court. Darshan Singh Ramakrishnan versus Maharashtra. Nowadays discussion crux is that the no cognizance can be taken by a magistrate in a complaint for commission of offence under section 223 of this BNSS, unless and until there is a notice to the accused, granting an opportunity of being heard. First notice, after hearing him, opportunity him, thereafter, if the court wanted in its discretion, can take cognizance. If he is satisfied with the reply of the, obviously he has to proceed accordingly. Now I think it is sufficient for today. Again, I will join you with new topic, new episode. Thank you. Thank you very much.